Welcome to this explainer. Today we're diving into a deeply unsettling perspective on modern family law. Most of us just view the divorce process as a personal tragedy, right? But critics are looking at it through a very different lens. They see it as a highly engineered, bureaucratic wealth extraction machine, one that takes personal pain and transforms it into a genuinely Kafkaesque nightmare. The system we're about to unpack has these deep, Machiavellian roots in medieval statecraft, and it seems designed from the ground up to consume the very wealth it's supposed to oversee. So let's dive right into how this architecture actually functions and how the distant past connects directly to your wallet today.
Okay, so let's start with a foundational concept that legal critics call fattening the pig. This is a general idiom, but in law, it refers to artificially inflating a situation, a dispute, or an asset pool, specifically to make it vastly more profitable for the middlemen before any final payout happens. And when you look at standard adversarial family courts, critics argue the system treats marital estates exactly like this. It's a highly profitable industry. Couples are essentially encouraged to grow their wealth together over years, only for it to be heavily skimmed by the legal system the second they separate. It's the ultimate structural horror where, quite literally, the process is the punishment.
So how exactly does this fattening happen in practice? Well, critics point to three specific tactics that heavily incentivize prolonged conflict. First, you have manufactured discovery and motion practice. Honestly, it's hard not to compare this to Franz Kafka's novel, The Trial, specifically that character Herr Hold, the bedridden advocate. Just like Hold charges endless fees while his client's initial petitions are just filed away completely unread, modern attorneys can vastly increase billable hours by filing incredibly aggressive requests for minor documents, just slowly draining the marital estate. Second is escalating emotional conflict. By framing every tiny disagreement as this high-stakes battle, attorneys keep clients angry and reactive, which pretty much ensures they'll approve really expensive strategies. And third, deliberately delaying settlement. The closer a case gets to an early compromise, the less money the lawyers make, so the system ensures the dispute survives long enough to rack up massive trial preparation fees through sheer artificial friction.
But, attorneys are really just one part of this ecosystem. The state itself, specifically through the tax code, acts as the ultimate catalyst here. It doesn't just passively sit back and watch a divorce happen. No, it actively provides these high-stakes, time-sensitive tax incentives that practically pressure couples into complex, aggressive restructuring. The tax code is effectively the lure that herds a family's wealth into one incredibly vulnerable place.
Let's look at the actual numbers, because the financial trap here is just staggering. If you are married and filing jointly, the tax code allows you to exclude up to $500,000 of capital gains profit from the sale of a primary residence. But the absolute moment you are divorced and filing individually, that exclusion drops right in half, down to $250,000 per person. The state is essentially offering these massive tax carrots to herd your wealth into one huge combined pool. And this acts as a financial funnel, making that wealth extremely precarious and incredibly costly to split up later if you happen to mismanage the timing of a sale.
This realization leads scholars to a pretty stark conclusion about what they call the illusory union. The traditional vows might say until death do us part, but the legal reality? It effectively treats marriage as a fragile temporary partnership. It's almost like a lease agreement that's meant to be broken. The argument here is that the state structurally plans for the breakdown of this union. By making divorce highly accessible through no-fault laws, while simultaneously keeping the financial unwinding incredibly complex, the state makes sure a massive chunk of that fattened estate is permanently redistributed back to the legal system through court fees, mandatory transactions, and taxes.
To really understand how this intricate machinery was built, we have to rewind and trace its Machiavellian roots all the way back to medieval statecraft. Way back in 1066, William the Conqueror establishes this absolute feudal land monopoly, where the king ultimately owned literally all the land. By 1250, legal scholars like Bracton start formalizing the definitions of what actually constitutes crown assets. And fast forward to 1540, we see extreme extractions, like the execution of Thomas Cromwell. The core theme across all of this is that the crown possessed absolute control over family estates, and they used marriage, and crucially separation, as a primary tool for wealth extraction and political control. Think about historical monarchs like Philip II of France or Henry VIII. They weaponized the Catholic Church's highly complex laws on consanguinity. Now, because almost all aristocrats were technically related in some distant way, the crown could easily discover an incestuous affinity. Just think about the sheer calculation in that word, discovered. It was a perfectly convenient tactical loophole.
They used it to annul a family's power base, dissolve rival alliances, and consolidate wealth whenever a specific marriage became politically inconvenient.
The crucial legal mechanism they used to pull this off was called delegitimation. You see, these historical annulments didn't just separate couples like a modern divorce does. They were far, far more destructive. They declared marriages void from the very beginning, and what that did was retroactively turn legitimate heirs into bastards. It permanently stripped them of their inheritance rights. It was this calculated, completely devastating way to permanently neutralize noble factions from uniting their territorial estates.
But what happened when an annulment just wasn't enough to dissolve a family's threat? Well, the state escalated to what was called the corruption of bloodline. It's a pretty haunting legal term, right? And it perfectly mirrors the modern destruction of the family unit for financial gain. The Tudor crown heavily utilized bills of attainder. These were legislative acts that declared someone guilty of treason without even having a formal trial. By corrupting the bloodline, the state legally severed the link between ancestor and heir, which ensured those massive family estates were completely confiscated and forfeited directly back into the crown's treasury. The sheer audacity of the state back then is just breathtaking.
And the profound irony in all of this lies with Thomas Cromwell. He was Henry VIII's chief minister and actually the brilliant architect of many of these exact royal legal maneuvers. Yet, he eventually fell from power and was executed under an act of attainder himself in 1540, stripped of all his titles, all his immense property, without a single trial. Cromwell's demise stands as the ultimate proof that this absolute, ruthless wealth extraction machine eventually consumes even its own architects.
Now, to pull this off continually, generation after generation, the state relied on a really nebulous legal fiction developed back in the 14th century, the concept of the crown. This legal theory essentially separated the king's physical, mortal body from his immortal body politic. By acting as the head of the nation, this concept granted the sovereign complete immunity from judicial process. This is the foundational concept that allows the process to become the punishment without any consequences whatsoever for the middlemen. It ensured that the crown, the ultimate butcher of these noble estates, was totally insulated from its own extractions.
Which brings us right back to the modern day, with a vital and frankly deeply concerning question. Who polices the hygiene of the legal conflict? If the medieval crown had ultimate immunity while it extracted wealth from families, who oversees the modern legal system that seems to share this exact same untouchable immunity while dividing our estates today?
Well, critics suggest the answer lies in what is called the Legal Barber Paradox. Think of that old philosophical riddle about the barber who shaves everyone who doesn't shave themselves. The bar operates as a very similar closed loop. They fiercely prosecute the unauthorized practice of law to maintain a strict monopoly. They enjoy system self-regulation, where judges are essentially judging their own peers. They possess complete judicial and prosecutorial immunity from the financial devastation their courts cause, and they actively reject any innovation, like automated efficiency, that might make dispute resolution faster or cheaper. This closed-loop immunity is perfectly mirrored in Kafka's tragic figure of Block the corn merchant. Remember him from the trial? He was a client who spent 5 years on trial, hired 5 different lawyers, and was ultimately reduced to this groveling bankrupt servant forced to sleep in a maid's room. That is the horror. The system requires this agonizing friction to survive.
So it leaves us with a truly profound historical question to ponder. If the system fundamentally relies on our natural biological and social urge to pair up and build wealth together, only to turn around and profit immensely off the friction of our separation, how do you avoid becoming just another Block the corn merchant? If the state acts as both the breeder and the butcher, and the modern legal process itself is the punishment, does the house always win? It's a challenging, really haunting question, and definitely one worth considering before signing on the dotted line. Thank you so much for joining me for this explainer. I hope it gave you a powerful new lens on a very complex topic.